Good morning, distinguished guests, colleagues, and friends. I think that today is good day. Yesterday is raining and it's quite difficult for traveling. So I think that today is great. And again, thank you for participants who come to our office today. And also, if you think that we have a small group of audience, actually we have the online audience as well. So we broadcast our seminar to around the world. You know, we have the registration for online, I think almost 80 registration. So I think that for today, it is our great honor that we have HKIAC to co-host this seminar with our firm Tilleke and Gibbins. If you think that you want to solve the dispute through the arbitration, I think that Hong Kong International Arbitration Center or HKIAC would be the one option and one of the most prestigious arbitration institute in the world, especially in the world that I think you cannot avoid that Chinese investor, the trade with China is more and more important. I say this why Thailand is, if someone know about the, for example, the trade concerning car makers, like in the past 20, 30 years, we probably use the fuel carbon car, right? Toyota, Honda, you name it, all the Japanese car makers. Also in Thailand, you know, Thailand is the top 5 car producer in the world. We produce 1.5 cars each year and mostly export. But recently, like in last 5 years, everything changed in Thailand. Same thing. What happened? We opened for the EV market, electric vehicle, right? So, you know, all the top brand of EV cars maker from China. Yes, Tilleke always have the Japanese car makers as our client. And right now we have a lot of Chinese EV car makers as our client. Also, one American brand, you know, like Tesla, that also our client as well. So if you are the foreign investor, you want to invest in Thailand, you want to know what is the business incentive, tax incentive in Thailand. Yes, these things always facilitate your business in Thailand. Why you want to come to Thailand? Maybe the ease of doing business in Thailand. One of the things maybe yummy food, right? Yummy Thai food, and a lot of activity that you can come and to do the work in Thailand easily. So I think that I bring you to the issue of the JV, joint venture agreement. Why you need a JV? You know, you have the innovation, you want to invest in some country like Thailand. We have like 70 million people, and we have the like sub-region, Mekong region. We have the good neighbors, some not good maybe, neighbor country. So I think that when the foreign investor come to Thailand, they come with the great hope that, okay, Thai law would support them for doing business in Thailand. But when they have the problem, the dispute with the JV partner, right? Who going to solve this dispute for them? If they think about Thai court, it's the number one question that my client asks me, whether or not we can trust Thai court or Thai judge. What do you mean by trusting them? I say that in my 25-year experience in Thai court, I think that Thai court, Thai judge, they honest. You heard some corruption? Yes, any country have corruption. But I cannot guarantee, but I trust Thai court. However, I told you that you can trust someone when you understand them. When you can understand them, right? They ask, can Thai court speak English? Can Thai court speak Chinese? Can Thai court speak French? Parlez français? No. I speak like this. I study in high school, but that is one sentence, right? So I think that one thing about Thai court is that Thai court have the limitation like other court in the world. Thai court, the right from lawyer, right? They study law, not all the business they understand, right? Not all the things that they have to understand. But if you need the expertise in the construction, in the factory, in the technology, I think that you need something else. You need arbitration. Why? Because you can choose the judge that expertise in the area that you want to solve the dispute, right? So I think that this is important because you know about a lot of arbitration institute in this world. But I can say that I told you that one of the most prestigious arbitration institute, I think about HKIAC. I know this name for a long time, even when I study law in Thammateeradaycho University, and even when I study LLM in Melbourne University in Australia. My lecturer in Melbourne, actually she was the arbitrator in HKIAC, you know. And that made me think that, one day I should visited HKIAC. Yeah, I visited HKIAC recently, not long ago. And also I follow them because they have a lot of activity for lawyers to learn about their rules. And also I think that I follow them to join the arbitrator training in Beijing. I think it's quite useful to know the HKIAC arbitration rules, how they help the party to solve the dispute through arbitration, how their rules would be efficient than other institutes. So I cannot tell you about the detail about HKIAC because we have today the expert from HKIAC, Miss Joanne Lu and Michelle Cheung. I hope that I spell your surname correctly. Okay, my Chinese faith didn't help. Okay, both of them from HKIAC and especially Joanne is the Secretary General. I think she take a leading role in HKIAC with support from Michelle. So I think that it's good day that they come to Bangkok and they share her knowledge, and they will let you know how, if you consider to put your arbitration clause in your JV agreement, probably you might consider HKIAC rules. Okay, before I close these opening remarks, I like to inform you that after this opening remark, Joanne and Michelle will share with you the HKIAC information, and then don't leave this room. Why? Because I have the really important case to share with you concerning joint venture agreement dispute relating to international arbitration, and it's also relating to Thai courts. This is a good, really, I can say it's really great case for learning. If the latest case happened here early of this year, and it's not finished yet. And this case is not my case. That's why I can share with you. Okay, I use this case study to teach my LLM law student in Thai Chamber of Commerce University. So I want to share again with you guys. Okay, thank you very much. Enjoy the seminar today.
Thank you very much, Ms. Noppramart, for those insightful remarks highlighting how joint ventures drive Thai investment abroad and how arbitration ensures stability, predictability, and neutrality in resolving JV conflicts. This is a perfect introduction to our next session, where we return to one of those world's most respected arbitral institutions, the Hong Kong International Arbitration Center, to learn how its updated rules can help parties manage multi-party, multi-contract joint ventures disputes. We are very privileged this morning to be joined by an outstanding panel from the HKIAC, who will share us with both institutional perspective and practical experience on managing complex joint venture disputes under the HKIAC administered arbitration rules. Allow me to introduce you to our distinguished speakers. Ms. Joanne Lau, Secretary General of HKIAC, leads the Center Global Operation and Strategic Direction. She oversees the management of cases administered in Hong Kong, Shanghai, Beijing, and Seoul, and has been instrumental in developing HKIAC initiative to enhance procedural efficiency, transparency, and diversity. Prior to her appointment as Secretary General, Joanne practiced international arbitration in London and Hong Kong, and she has been recognized by Chambers and Partner, Legal 500, and Who's Who Legal as one of Asia's leading arbitration professionals. Ms. Michelle Cheung, Counsel at HKIAC, played a key role in case administration and rule development. Before joining HKIAC, she practiced as a barrister in Hong Kong, focusing on construction arbitration and commercial litigation, and also trained in an international arbitration group of major London firm. She will highlight the latest amendment to the HKIAC rules, including innovation on consolidation, joinder, expedited procedure, and emergency arbitration. And as Ms. Noppramart mentioned earlier, she will come back and continue the next session with the topic about JV dispute in arbitration case, lesson from real proceedings, where we will analyze the real cases and key takeaway from Thai and international perspective. Please join me in giving a very warm welcome to Ms. Joanne Lau and Ms. Michelle Cheung.
Hi, everyone. Thank you once again to Noppramart and the Tilleke team for the warm welcome. It's a pleasure for me and Michelle to be in Bangkok to see you all and to share some perspectives from HKIAC. I know a lot of people are joining online today, so hi to everyone who is dialing in virtually. I think we can get started. I think you've had our introduction, but perhaps when I begin, I'll just briefly touch on what we plan to cover today. So in the next 30 to 40 minutes, this is how we structured it to tell you more about what is HKIAC, who we are. And secondly, we want to share some insights from our cases, in particular, the latest case statistics from 2024. And we'll try to bring out some of the figures that we have in relation to Southeast Asia. And then we'll turn to our 2024 administered arbitration rules, some features that you should pay attention to. And finally, and as Noppramart also mentioned at the start, HKIAC has a very diverse and international caseload. But in addition, we are also known for our unique strength and expertise in handling China-related disputes. So we do want to also highlight what the strengths of Hong Kong as a seat and HKIAC as an institution is when you're dealing with China-related transactions and disputes. So that is a rough outline, but given for the in-person group at least, today we have quite a nice casual setting, so we would welcome, I'm sure, speaking on behalf of Michelle, to welcome questions, comments, interactions with you all. So please don't hesitate if you want to interrupt us anytime with questions. So first of all, HKIAC, who we are. We were founded in 1985, and as you can see from our logo, we are celebrating our 40-year anniversary this year. But having done a tour at Tilleke just now, I realized Tilleke has a much longer history. But nevertheless, for HKIAC, it's a milestone year for us. And over the years, we've accumulated significant case management experience. We have handled over 13,000 cases to date. We are regularly recognized as one of the top 3 arbitral institutions globally, including in this year's Queen Mary survey, where the HKIAC rules were ranked the first in Asia Pacific and joint second globally. We are an independent and non-profit association. Sometimes we get questions from people asking, oh, is HKIAC governmental organization? Are you quasi-governmental? Are you related to any other regulatory authorities? But actually, all of that is no. HKIAC was set up by a group of business people, and today we're independent, non-profit, financially self-sufficient, which ensures our neutrality. And finally, one-stop shop. Even though we have arbitration in our name, and we'll focus on talk about arbitration today, HKIAC also handles different forms of dispute resolution services, so including mediation, adjudication, domain name dispute resolution. We also organize a lot of alternative dispute resolution events and trainings just to help build the community and to help with capacity building. So we have 4 offices, so Hong Kong being our headquarters. Seoul was our first rep office outside of Hong Kong. Our Shanghai office is celebrating its 10-year anniversary this year, and the latest addition is our Beijing office, which we opened in December 2024, just last year. The Shanghai-Beijing offices are quite significant in that HKIAC was the very first offshore institution to have set up a presence in mainland China in 2015. And we are also the first offshore institution to have set up a presence in Beijing. So another illustration of HKIAC's long track record as an international institution with unique strengths in handling China-related work. So today we're focusing on talking about our arbitration services. So as an institution, what does HKIAC do? First of all, and the largest part of our work is case administration. And Michelle later on will talk more about what exactly do we mean by administering cases. But for us, the 2 main rules which we administer are HKIAC's own rules, our administered arbitration rules, the latest one being the 2024 one. And the other one is the unsatro arbitration rules. Actually, these days, there are still some parties who would pick unsatro arbitration rules in their contract and to say that they are to be administered by HKIAC. So we also do that. HKIAC also has a unique position in Hong Kong. So even though there are multiple dispute resolution institutions in Hong Kong, we are the only institution that is specified in the statute, the Hong Kong Arbitration Ordinance, to provide arbitrator appointment functions in ad hoc Hong Kong seated arbitration. So that's HKIAC. And in addition, fund holding services. So even if there are some cases which are not necessarily administered by HKIAC, and in some instances even administered by other institutions, sometimes parties and tribunals would come to HKIAC to ask us to help them with holding funds. So that's something that we can also do. Tribunal secretary services, that is a very distinctive feature of HKIAC. We started doing that over a decade ago in providing tribunal secretary services for tribunals, and which is a very effective time and cost saving measures because tribunal secretaries tend to have lower hourly rates compared to tribunal members. And HKIAC, we also have our own premises, so if any of you are in Hong Kong, I know some of you are based in Hong Kong, probably, James. We have very nice premises for hearings and events. So we've included a real picture here showing you what our hearing room looks like. Over to you, Michelle.
Thanks, Joanne. So I'll take over here to just talk a little bit about our team. So as you can see, this is the secretariat. So this is the staff that works in our day-to-day operations in our center. So Joanne and I are both technically staff of the secretariat at the HKIAC. We're very international, so there's 9 nationalities and 7 languages across the board. The secretariat are all legally qualified in both common law and civil law jurisdictions and have different backgrounds, and have also attended universities in various parts of the world. For example, Victoria over there at the end of the top row handles a lot of Russian cases, which has been quite important in our recent development in our work with Russia. She's the only Russian-speaking member of the secretariat. So this is a little bit on the structure of HKIAC. We have Rimsky and David, who are part of the executive committee, who oversees all of HKIAC's work. So they are part of the HKIAC Counsel. Below that, there is the Finance and Administration Committee, the Proceedings Committee, and the Appointments Committee. I'll go on to talk about the Proceedings and the Appointments Committee a little bit more in a second. And then underneath that, in terms of structure, that is the HKIAC Secretariat, which we saw just now on the previous slide. So as Joanne mentioned earlier, the Secretariat handles arbitration, mediation, domain name dispute resolution. But apart from that, we also have a business development team that handles obviously BD and marketing and lots of events, and are very important in a part of what we do and promoting HKIAC both in Hong Kong and internationally. So this is both our Proceedings and Appointments Committee. As you can see, it's a very international group of practitioners with various backgrounds. They come from different parts of the world, and we have both in-house lawyers, barristers, law firm partners, as you can see. And so just a little bit first about the Proceedings Committee. The Proceeding Committee overlooks and handles all our procedural matters. So how this generally works on a day-to-day basis would be a member of the Secretariat will draft an agenda and regarding procedural matters that require the Proceedings Committee to approve. And this can involve issues such as multiple contracts, single arbitration under multiple contracts, consolidation of arbitrations, expedited procedure, and other procedural matters, and which could also involve non-signatory issues. And this agenda will often go up to the Proceedings Committee, and the Proceedings Committee will approve our approach or disapprove our approach, and we'll proceed accordingly in the manner that the Proceedings Committee has discussed and designated. In terms of the Appointments Committee, as the name shows, they handle appointments. So in a very similar manner, the Secretariat will be the first layer that suggests appointments towards the Appointments Committee, and in a similar manner, the Appointments Committee will approve or give alternatives for an appropriate arbitrator to be appointed in such case.
So So if I can just add, I think this structure is actually crucial when people talk about, oh, how do you ensure that HKIAC is neutral? How do you ensure, oh, even if I'm a party from mainland China or I'm a party outside of mainland China, how do you ensure that there would be no biases? And as you can see here, these are not internal people at HKIAC's secretariat, but really established leading practitioners from different places. So, and unlike some institutions, we don't form like small groups in deciding, say, a single appointment. Every time there's an appointment that HKIAC needs to make, it goes through the whole committee who would, as Michelle mentioned, look at each recommendation and provide their views and vote by majority. So there's no like biases in favor or against any parties at all. If you look at other institutions, some institutions call this sort of function the Court of Arbitration. So for us, our Proceedings and Appointments Committee perform similar functions as that.
And then, so firstly, just some insights into our cases. So just a quick look at our 2024 statistics. We had a great 2024. It was a record number of new cases filed for us with 352 new arbitrations. And of note is that they were commenced under 510 contracts, meaning that there were many cases that were commenced as a single arbitration, but under multiple contracts. So our secretariat is very experienced in handling such cases. So there's a side-by-side comparison of cases over the past 5 years, starting from 2020, showing the significance of 2024 for us. And this is the contract date of contracts that were signed in terms of our 2024 cases. And of particular note is that there were many contracts, as highlighted in the orange at the end of this slide, that were signed in between 2020 to 2024. Now, this is really significant for us as it shows that many recent contracts have included HKIAC as the arbitration center in which their disputes have gone to. So it shows the trend that parties are continuing to use HKIAC as an arbitration center. So this is just a map to show our global reach. We have had parties from 53 jurisdictions and Hong Kong. So at the bottom of the slide, it shows the top 10 jurisdictions from 2024. Hong Kong and Mainland China often come up as the top two, and often closely followed by BVI and Cayman Islands, which are usually places for a lot of other jurisdictions to incorporate their companies. Followed by Singapore, US, UAE, South Korea, Marshall Islands, and the Philippines. A lot of Southeast Asian countries do come up, and in 2024, it so happened that we had the most number of Philippine cases, but that figure often changes for us. Now, in terms of our case statistics, 199 appointments made by HKIAC, 76.4 international cases, which is important for us. But most important on this slide is the total amount in dispute in 2024, which was USD 13.6 billion, which was very significant for us, and it was one of the highest, if not the highest, amount in disputes in the Asia-Pacific region amongst institutions. So that is a statistic that is very important to us in 2024. The governing law is quite interesting. We often do see Hong Kong and English and Chinese law as our top, but also 12 different governing laws chosen in total, including some in Southeast Asia. And languages of arbitration, 79.3% cases conducted in English, 15.3% in Chinese, and 4.3% bilingually in English and Chinese. So that is a function that our secretariat does. We do conduct cases bilingually. And yeah, so this is mainly our statistics in 2024. I'll hand back to Joanne.
And the final point just on seat, Hong Kong seat is the most popular seat that we see, and it's a very safe seat, but occasionally we also see parties choosing other seats maybe as a result of commercial negotiations. So we've seen like London, I think recently we had one in Dubai, another one in Turkey. So like really interesting. As an institution, we're agnostic to the seat in that we can still administer cases even if it's seated elsewhere. But as we'll come to later, Hong Kong, of course, is a very good choice. So turning to sector and case types, if you look across at all our cases, the top sectors are pretty consistent in that the top one is commercial and corporate disputes. We also see a lot of banking and finance disputes. Construction is another one. Maritime arbitrations as well. So those are a selection of the common ones, but we've also done a breakdown to look at the higher value cases, and this is arbitrary, but say if we're talking about cases over 50 million US dollars, we looked at what's the common sector. So 30% actually involved a party in the financial investment or banking sector, and then followed by parties in the energy and natural resources sector. And the third one, which we also saw quite a lot in 2024, pharmaceutical, life sciences, healthcare, and then retail, e-commerce, and finally TMT, technology, media, telecommunications, another very active sector for high value disputes. And as to what agreements they arise out of, the first one is facility agreements, guarantee agreements, loan agreements, often perhaps not as straightforward as simply like a non-payment of a loan. Like some of the more complex ones would be, say, project finance related, or trickier arguments like misrepresentation rather than a simple non-payment of a debt. The second one, which we've put in bold, is because of our topic today, joint venture disputes. And we do see a lot of those, perhaps as a subset of shareholder disputes. And we'll come to it a little bit later on what sorts of JV disputes that we see. And finally, and similar to shareholder agreements, and often we see arbitrations being commenced under both shareholder agreements and the SPA, the share purchase agreements, at the same time. But quite a lot of those give rise to disputes as well. Turning a bit more on arbitrator appointment statistics. So, of course, in most of our cases, I would say, usually the parties, they pick their own arbitrators. So this is something that some parties, I think, maybe might misunderstand that as an institution, will you decide the dispute? But I think actually the more important point is that in an arbitration, parties, you have the autonomy, the freedom to choose your own arbitrators. And in most cases, if parties are participating, they would exercise that right and pick the person they want. And in those instances, HKIAC's role is confined to confirming the arbitrators. So in 2024, we confirmed 220 arbitrator based on parties or co-arbitrators designation. Sometimes, maybe because a party is not participating or the co-arbitrators are unable to agree on someone, then HKIAC does need to exercise an appointment function. And in 2024, we made 199 arbitrator appointments. If you look at the arbitrators appointed by us, again, a very diverse pool. So we appointed arbitrators from 25 different nationalities and geographic origins in 2024. And if you look at the breakdown, the top is arbitrators from Hong Kong, followed by UK, Australia, Mainland China, Singapore, and others in top 10, US, Canada, etc. So a pretty mixed group of arbitrators. And we also looked at arbitrators from Southeast Asia, given we're here today. And in the past 5 years, we made appointments of arbitrators from Southeast Asia in the number of 154, so a pretty healthy number. The final point is we also look at diversity statistics, and we saw just now Tilleke also a very staunch supporter of diversity, including gender diversity, and we look at those statistics too. So in 2024, in terms of our female appointments, around 35% were female. Around 37% were new arbitrators who have not been appointed by HKIAC in the past 3 years. HKIAC, we have a panel and list of arbitrators, but when parties choose arbitrators, they are free to go outside of the panel and list. But nevertheless, parties and HKIAC too, we often consult those two lists when thinking of who to appoint. And on that panel and list, it includes arbitrators from 74 different nationalities. And for people who are interested in joining the panel and list, the appointments committee that Michelle talked about just now, they are responsible for screening applications and deciding whether to approve their inclusion to our panel and list. And some statistics about our cases with Southeast Asian parties. So from 2020 to September 2025, so just last month, we have had 270 cases involving at least one Southeast Asia party. So you see on this slide the different jurisdictions, of course, including Thailand. And as Michelle touched on just now, we often see cases governed by a variety of different governing laws. Hong Kong English, of course, being very commonly chosen, but as you see, Thai law is included in the list as well. Parties often think of HKIAC when they have complex, high-value disputes. Of course, we see a range, so we see very small cases too, going up to large cases. But if you look at our last 5 years, disputes involving Southeast Asian parties are up to $6 billion, so pretty high. And even in this year alone, to date, up to end of September, already 45 cases involving Southeast Asian parties and $846 million. Yeah. So we've picked out one case which involved a Thai party just to illustrate how it worked in practice at HKIAC, but of course anonymized, and so you can't tell which case it is. But just to illustrate, a commencement of arbitration March 2023, Thai party and a Hong Kong party choosing HKIAC 3 arbitrators. In May 2023, the tribunal was constituted. And in that case, again, like very diverse panel. There was a Hong Kong arbitrator, one Canadian/Philippines arbitrator, and the presiding was an Australian arbitrator, I believe picked by the co-arbitrators. The first round of pleadings, the statement of claim and statement of defense, were filed July-August 2023. This was followed by a second round of pleadings in December 2023 and January 2024. A further round of expert reports were filed in April 2024, and then a hearing took place with a final award issued in June 2024. So this is quite a standard procedure for HKIAC arbitration, and from start to finish, you can see approximately 15 months here. So a pretty standard one, and not a particularly low value one either. I think this was above $10 million. So just an illustration of how efficient HKIAC arbitrations really is, with the illustration of a real case scenario. And then on joint venture disputes at HKIAC, we do see a lot of those, including JV disputes involving Chinese parties, like Chinese party or a founder, and then a investors from elsewhere. Of course, not confined to China-related JV disputes either. We also see lots of just general commercial corporate disputes, shareholder disputes. But in terms of the types of JV disputes that we see, I think there are a few areas which commonly give rise to arguments or alleged breaches. One of them, I think, is on governance and control. So arguments about, and maybe Noppramart will touch on this more later, arguments about the direction that the JV company is going, or alleged breaches of corporate governance rights, like people arguing, saying, hey, this transaction should have been approved at board level. Why was it not approved and you went ahead? I think in China-related JV disputes in particular, and for those who have done it in the room, there are often arguments about the very important seal of the Chinese operating companies, whether the company seal has been misused, whether someone forged the company seal, whether someone stole the company seal or withheld the seal so that no one else could use it, so quite common. Arguments about whether one JV partner is doing something to the detriment of the JV company or in competition of the JV company, so all to do with governance and control. Financial breaches is another category, so arguments about whether there's misappropriation of assets or unauthorized transactions leading to assets leaving the JV. Failure to provide audited accounts or sometimes management accounts, failure to observe obligations to inject capital into the JV, very common. And these couple of years, we've also seen more we call non-breach trigger events, so trigger events to redemption rights, for example. So sometimes in the shareholders' agreement, parties would agree that, okay, you need to reach a milestone by a certain date. For example, being ready to commence an IPO by X date. And if you fail to do so, then automatically that triggers a right for one of the shareholders to exercise a put option. And finally, exit. So say if they exit, they won't wish to exercise the put option. The other party either says, okay, the ground for you to exercise the put option, for example, on the basis of material breach, has not been satisfied. So they fight over whether they can really ask for their shares to be repurchased. Or it could be simply the company saying, oh, sorry, I don't have any money right now, and my obligation only arises if there's legally available funds. So there could be an argument around it. So these are some of the typical arguments that we see. And then on the relief sought, so often specific performance or injunction, damages, or like a request to be bought out. So these are some of the reliefs that parties would seek.
Okay, so now I'll go on to discuss the 2024 rules a bit. So the 2024 rules came out in June last year to be the latest version of the HKIAC rules. The previous rules in place were the 2018 rules. So it has been 6 years, so we were due for an update. So these are some of the goals and aims that the committee had in mind when drafting the 2024 rules. So cost saving, time saving, efficiency, and integrity, which are all obviously very important aspects in arbitration. And at HKIAC, we are aiming to make the process as efficient and as easy for the parties to use and go through. So we will discuss some specific features in the next slide. But basically, just of note here, cost savings, we do have Schedule 2 and Schedule 3 as the fee method for determining the arbitrator's fees and expenses in our rules. So Schedule 2, which is our default position, provides for the fee method to be by way of an hourly rate. So this is capped, as you can see, at 6,500 Hong Kong dollars, or approximately 800 US dollars. And this will often be on the basis of the arbitrator's proposed rate. And when doing this, we will also take into account the size of the case, so the amount in dispute. And the second method is Schedule 3, which is based on the sum of dispute only, so kind of like an ad valorem method. And this has to be agreed by both parties, so claimant and respondent both must agree to use Schedule 3 in order for this to be used. And this will be based on the total amount in dispute of the case, so this will be based on the claim and the counterclaim, this combined amount. And we do have a schedule in our rules that shows what the absolute maximum amount of fees can be paid to the arbitrator based on this sum. And then in terms of time-saving measures, of note is our expedited procedure and emergency arbitrator procedure. So the expedited procedure provides for the arbitrator appointed to issue an award within 6 months of the date of the transfer of the case file. And this date will be made known to the parties. It will be the date that we send a physical case file over to the tribunal. And then in terms of the emergency arbitrator procedure, this is usually when a claimant is seeking some sort of emergency relief, and our role at HKIAC is to appoint the emergency arbitrator within 24 hours. So this is a very quick and urgent measure for the parties. And then in terms of efficiency in complex arbitrations, as mentioned before, we do have the option of single arbitration under multiple contract. The 2024 rules actually made a change in this aspect, which allows for HKIAC to not take into account the party designated arbitrator when the case is conducted under a single arbitration under multiple contracts. However, in practice, we do aim to maintain party autonomy, and where there are no particular issues of note, we do try to appoint the arbitrator that has been designated by each party. And in terms of the integrity of proceedings, something new in the 2024 rules is that HKIAC now has the power to review the tribunal's fees. However, this is only done in very exceptional cases and is not something that HKIAC often does or has done so far, I believe. So in terms of how long an HKIAC arbitration takes and how much, I think Joanne covered this briefly in our example case earlier, but just some numbers and statistics for all of you to take a look at. Average duration is 17.7 months, so just over Joanne's example just now. The expedited procedure is 6 months. That is the absolute maximum unless an extension is sought or agreed by the parties. So this number should be 6 months. And in terms of fees, this is the fees for both HKIAC's administrative fees and also the tribunal's fees. So the mean and median includes both the fees combined. And as you can see, this is data taken over 10 years, so from 2013 to 2023. So HKIAC charges its administrative fees based on the sum in dispute, and it is capped at 400,000, and we do, Hong Kong dollars, of course, and we do have a schedule on our website and our rules which shows what amount in dispute equates to how much we charge in terms of administrative fees. So this is clear and transparent for the parties to begin with when they commence an arbitration. So this is just an example of a model clause for parties to use in their agreements, whether it be JV agreements or other agreements. And this is just a clause that makes it very clear that an arbitration will be administered by HKIAC, and the number of arbitrators, seat of arbitration, proceedings will be conducted, so in a certain language. And something new we've added into our model clause is, as I mentioned just now, the method for determining the arbitrator's fees and expenses, so whether it be by Schedule 2 or Schedule 3. I think this is very important because we do get a lot of arbitration clauses that are not totally clear whether HKIAC should be administering the arbitration or not, or the number of arbitrators. So using the model clause just makes it much easier for parties to commence arbitration should a dispute occur.
Yeah, and just on the point on a model clause, we sometimes get like funny clauses, which we would share amongst the team. I think once we had one which said parties want to pick England and Wales International Arbitration Center in brackets HKIAC. So like it feels like an obvious like typo as people are negotiating last minute. And recently we had another one where parties want to submit their disputes to a lawsuit at a arbitration institution or court in Hong Kong. And then the parties chose to commence it at HKIAC, then there will have to be an analysis, including by our proceedings committee, as to whether HKIAC has the prima facie power to proceed when there's an optional clause and when HKIAC is not specified in the clause. So therefore, use the model clause. Finally, I mentioned in my overview, we'll just touch on our strengths in China-related cases. And I think people in the room are probably, or at least have some familiarity with Hong Kong already, but given HKIAC is based and headquartered in Hong Kong, I'll just talk about what are Hong Kong's strengths. I think, first of all, in terms of the legal system, it has a very established, reputable common law system. And because Hong Kong has always been a financial center with lots of people choosing Hong Kong to raise funds, to have a listing, IPO, lots of M&A deals going on. So that's why even in the Hong Kong courts, there has been a very rich jurisprudence, especially in commercial matters. And that is important because by choosing Hong Kong law, parties get the predictability as to what different issues would potentially be interpreted under Hong Kong law. I think the culture is an interesting aspect of Hong Kong. We're part of China, so we have that Chinese heritage, but at the same time, say Hong Kong very special with English and Chinese both being official languages in Hong Kong. So people are very culturally diverse, very adept and experienced in working with Western businesses, also Chinese businesses, so a very international business culture, like say Michelle and me, both of us, for example, fluent in English and Chinese. The judiciary is very important for Hong Kong, independent judiciary. So Hong Kong has its own final court. The Hong Kong Court of Final Appeal has final adjudication over our matter. So that is separate from courts in mainland China. Legal talent pool is very deep, very diverse. So we have two legal professions, solicitors and barristers, both independent, self-regulated. And finally, I've mentioned just now, in terms of the capital markets, the commercial side of Hong Kong, free flow of capital, which is unlike any other Chinese city on mainland China, and a very deep capital pool. I think Hong Kong has topped the global IPO markets this year. And Hong Kong as a seat of arbitration, I mentioned just now, it's a very safe, reputable seat. So even if you look at the Hong Kong court's enforcement statistics, say in 2024, out of 100 applications to set aside, 100 applications to enforce arbitral awards, the number of applications which was not granted, so setting aside the enforcement application, there was only one out of 100, so that's very strong. Hong Kong is one of the oldest Asian jurisdictions to have adopted the UNCITRAL model law, so a very sophisticated, experienced arbitration jurisdiction. The law has continuously been modernized, so third-party funding, contingency fee arrangements with lawyers, arbitrability of IP disputes, those are all provided for under the Hong Kong Arbitration Ordinance. For our courts, we have specialist arbitration judges. And some of you may have heard of Justice Mimi Chan, who has been in that position for over 10 years now. Very good reputation, very bright. And finally, on interim measures and enforcement, there are unique arrangements between Hong Kong and Mainland China. So focusing on interim measures first, I think for people outside of China, this may be strange as to why you need an arrangement on interim measures. And the reason is, in Mainland China, if, say, you pick a seat outside of China, say London, Singapore, or elsewhere, even if, say, a tribunal grant you interim measures in your arbitration, that is of no use in Mainland China because there is no mechanism for Mainland Chinese courts to enforce those tribunal-issued interim measures. And if you're thinking, oh, then I'll just go to Mainland Chinese courts and ask them to grant interim measures in support of my foreign-seated arbitration. Again, there's no mechanism for Mainland Chinese courts to do that. The only exception outside of Mainland China is if you pick a Hong Kong-seated arbitration and administered by a specified institution, including HKIAC. So if you have a Hong Kong-seated HKIAC arbitration, then parties are able to rely on this unique arrangement to get interim measures from Mainland Chinese courts. So this is why it is powerful, because that's the only way, say, if you do want to, say, secure assets as you're arbitrating your dispute, then you have to go with Hong Kong-seated HKIAC administered in order to have that ability. So that has been a very significant development for Hong Kong and Mainland China. And so far, it has been used very regularly by parties, actually, and HKIAC has accumulated significant experience in that. So since 2019, we have already seen 151 applications. So in those applications, HKIAC would issue letters of acceptance to confirm that a Hong Kong-seated HKIAC arbitration has indeed been commenced at HKIAC. And mainland courts have been readily granting applications. So in terms of assets which have been frozen under the arrangement, that has come to $5 billion since 2019. But it's used by actually both Chinese applicants and non-Chinese applicants. So approximately 80% of applicants are foreign applicants. And in terms of respondents, around 60% are mainly mainland Chinese respondents, 40% are foreign respondents. So used by both and very effective. And the other China-related strength for Hong Kong, HKIAC, is enforcement records. So if you're talking about enforcement in mainland China, I know it's a little bit counterintuitive in that people might think, oh, if I have a likelihood of having to enforce in mainland China, should I stay away from Hong Kong because Hong Kong is part of China? But actually the opposite is true. If you choose Hong Kong HKIAC, you have better prospects of successfully enforcing in mainland China just because of the arrangements and the depth of experience that mainland Chinese courts have with dealing with HKIAC awards. So in the past 20 years plus, only 3 HKIAC awards are known to not have been enforced in mainland China. So this is a very strong record. And even internationally, enforcing HKIAC awards have no issue. So we have a stellar enforcement record. Of course, at an institution, we only hear things if, say, there's something going on in the courts and it gets reported. But even from public reports in the past 2 years, we've seen examples of awards being enforced in Australia, Cayman Islands, England and Wales, New York, etc. So very strong records. So I think that's all that we have in covering. I won't go through the slide given we've talked about it, but just a summary slide to set out why HKIAC and why parties should think of us. We're open to taking questions, or if Noppramart, you prefer to finish. Yeah. Any questions?
Hi, I'm Nicholas Tang. I have a question on whether there's Thai parties have used HKIAC, whether you can share some data or statistics on that.
Yeah. I don't have the exact number. I don't know. We do get a handful, I would say a handful of cases involving Thai parties every year. Say this year, we definitely had at least one case involving Thai party. And the case that I shared just now is a 2023 case. And I think that year, this is not the only Thai case either. There must be a handful.
Yeah, so I can't speak for other counsel, but for my cases, I have one case involving a Thai party this year, and it's to do with sourcing materials for steel pipes. The other party is not Thai, so only one side is Thai, and the tribunal has been constituted in that case.
Hong Kong law from contract, right? Yes. You probably don't off the top of my head. Yeah. I'm pretty sure it's Hong Kong law. Yes.
Thank you. May I have a question? Concerning the interim measure, right? If party choose Hong Kong seat and they want to apply for the interim measure, right? Can they also go to Hong Kong court directly? Or they have to come to the HKIAC in order to have the emergency arbitrator to consider on the emergency interim measure application?
So the arrangement actually, the interim measures arrangement that I talked about just now, has not really changed anything in terms of getting interim measures from Hong Kong courts, because the Hong Kong law has always provided for the possibility for parties to get interim measures from Hong Kong courts. So say if it's a Hong Kong seated arbitration or a foreign seated arbitration, there are provisions in the arbitration ordinance which allow parties to go to Hong Kong courts to get interim measures in support of the arbitration. So parties might not even have to rely on the interim measures arrangement. And Hong Kong being a common law jurisdiction, if parties say want asset preservation orders, injunctions, then the usual standards need to be satisfied, for example, whether there's a risk of dissipation of assets, etc. But say if you are a party and you're thinking of, okay, I need urgent measures to secure assets, I need interim measures, what are the options? There are a few. One, of course, as you say, okay, Hong Kong courts, they can provide help, or maybe they are the court of the seat, so that's why you're thinking of them. That's one option. The other option is to rely on emergency arbitrator provision. So coming to HKIAC, asking for an emergency arbitrator, and then you get a decision in 14 days, which is also enforceable in Hong Kong. So that's another option. Third option, actually, the interim measures that you need is in Mainland China. You can then rely on the interim measures arrangement to seek interim measures from the Chinese courts. That's a third option. I guess fourth option is actually you feel like, okay, I can wait until the tribunal is constituted, wait for 1 to 2 more months, and then ask the tribunal to issue interim measures. That's a fourth option. And I would say those are not really mutually exclusive. I suppose, save for if you already have an emergency arbitrator order, then a party might not necessarily think of, okay, let me also run to the courts to get help. But these are different possibilities.
Yeah, okay. One follow-up question. Since you said that the party can consider to get the interim injunction from Hong Kong court, and also can have other 3 options, including the request from the emergency arbitrator. Do you have statistics that whether party prefer the court or to go to the direction of the emergency arbitrator?
In China-related cases, I think the vast majority of parties have chosen the interim measures arrangement, so going to mainland Chinese courts. And one reason is that emergency arbitrator orders are still not formally enforceable in mainland China. So there's no formal mechanism in mainland China to enforce, say, an emergency arbitrator decision. We know that it has been done in mainland Chinese courts, but some parties feel that, because the legal basis is still a little bit unclear, I prefer to use the tried and tested method of using the interim measures arrangement. So that is that is the main one. But say if you're talking about Hong Kong courts, how often have parties gone to Hong Kong courts to get interim measures? Because parties don't need to come through HKIAC in order to do that. So we don't have any statistics as to how often parties would do so.
How fast that the emergency arbitrator can issue the order? You said that 14 days is the limit.
Limit, yes. So that's a must. Yeah, and Michelle has handled many emergency arbitrations too, so she would know. Yeah, on average, we appoint an emergency arbitrator within 16 hours, actually. So our requirement under our rules is that we need to appoint someone within 24 hours, but on average, for us, we actually managed to appoint within 16 hours. And then the emergency arbitrator needs to issue their decision in 14 days.
You probably have the list of the emergency arbitrator on the list, right? That's why you can appoint them quite quick within 16.
Yeah, but actually every time we need to make an appointment, we reach out to a group of people because not everyone necessarily have the availability to do something can be able to set aside that period of time to do it quickly. So we still need to ask around. Yeah.
Okay, thank you.
Thank you so much.
Some Thai parties will say, I don't want to use the HKIAC arbitration clause because we don't want to fly to Hong Kong for the hearing. So we prefer to use domestic tribunals. Can you suggest how a Thai party could arrange such that the hearing could be done in Thailand instead of Hong Kong? Is it possible?
Yeah, possible. And that goes back to the point about how legal seats. So even if you choose Hong Kong as a legal seat or you choose HKIAC as an administering institution, parties do not necessarily have to come to Hong Kong for the hearing. Of course, we would want them to because Hong Kong is a nice place to be and good food as well. But we have seen, some parties, if that's important to them, they could specify in their clause to say, seated in Hong Kong, administered by HKIAC, but hearings should take place in Bangkok, for example. And we've seen parties doing hearings at different places, like say some arbitration institutions in Bangkok may be able to provide hearing space. We've also seen parties choosing to run their hearings out of the arbitrator's office or out of a hotel conference room. So we've seen that. And especially after the pandemic, we've also seen a lot more hybrid hearings or even virtual hearings. So say HKIAC, we support fully virtual hearings as well if parties just want to do it online. And I think maybe less relevant for Thai parties, but for parties in certain places, our Beijing office and Shanghai office are two other options if they, for whatever reason, prefer to fly to mainland instead of Hong Kong.
May I ask about the interim measures? Like, I would like to know the example of like the interim that the party would like to apply in the mainland Chinese court, because I so know that like in China, their concept of law about like the ownership of the property is quite unique. So I would like to know like what type or what they would like the Chinese court to grant it to their interims, like when they apply with the HKIAC.
So first of all, on the type of interim measures that parties can seek, there are three types: asset preservation, evidence preservation, and conduct preservation. Conduct preservation, more like the common law concepts of specific performance or injunction. But the majority of the applications that we see are asset preservation orders. So we can focus on that. In order for someone to get that, and I'm speaking a bit from my counsel experience now back in private practice, Chinese courts often look for what's known as property clues. So some evidence to indicate that the property does belong to the party, to the arbitration. So we've seen parties say bank accounts where they can identify it belongs to the person, or land property, or shares of companies. But I think Chinese courts would need to see that it is actually owned by the person, so not by the person's wife or their business partner or their subsidiary, so it needs to be owned by the person. Yeah, I don't know if I've addressed your question.
Thank you.
A lot, but just often that I do think the burden is obviously on the person applying for the interim measures. So usually when the claimant, usually assisted by Mainland Chinese Counsel, apply to us for an interim measures application and letter of acceptance, they often provide exhibits with a list of what Joanne has just mentioned in order to meet that burden for evidence. So yeah, often it's property, how they've managed to identify that this belongs to them, or a bank account with, it's usually quite a heavy list of documents to show that such assets belongs to the respondent.
And often, yeah, I guess in most cases, if not all, on an ex parte basis when they first applied for interim measures.
Thank you.
I would like to know about how effective are your enforcing and award in the state that are not the party of the New York Convention?
Hong Kong, you mean?
In the other state that are not the party of New York Convention.
That is a difficult one. I think the reason is New York Convention, if I'm accurate, it has 172 different member states now. So actually the enforcement record is very strong. So I'm not sure how often it is that parties would go to a non-New York Convention state anymore for enforcement of awards. But maybe to give you one example, like Taiwan, for example, I think it's not yet a member state of New York Convention, but it has implemented legislation on grounds, and the grounds for refusal of enforcement of awards are actually similar to the New York Convention grounds. So in that sense, even if someone goes to Taiwan to seek an enforcement of a Hong Kong award, the approach isn't that dissimilar to a New York Convention award. And from recollection, I think in Taiwan, Hong Kong awards have also been, and HKIAC awards have been successfully enforced.
In terms of, let me introduce myself. I'm Chu Search. I'm co-director of dispute solution of Tilleke Gibbins. And thank you for your good presentation. And I have a question about in terms of the statistic. what percentage of Thai party which use the HKIACs a year?
Yeah, that's a very good question. We've put a we only did a statistics of all the Southeast Asian parties, so I don't have the exact breakdown. But I would say each year we have a handful. So each year we have around, I would say 250 to, last year we had 350 cases, 250 to 350 cases. Each year we get at least a few with Thai parties. So maybe not the biggest proportion of our cases, but we do see them regularly. So say this year, as Michelle mentioned just now, we have 2, I think, or at least in your cases, Michelle is handling 1. Last year we've definitely seen, and the example that I've given, another one that we were able to quite easily pull out, so a few, yeah. We hope to be seeing more, so for lawyers in the room, think of HKIAC as a very, very good choice, yeah.
May I ask one last question? I would like to know that what criteria that arbitrator used to choose the governing law to apply the case beside the contract.
I think this one may be difficult to provide a general answer. In most cases, we've seen like the governing law is specified, and we definitely encourage parties to specify the governing law in their contract to prevent arguments. But if there really is no governing law, then from an institutional perspective, like we would try and go with someone who is qualified. Say if there's an argument whether it should be Hong Kong law or PRC law, then we would try to go for someone who has familiarity with both laws. And when a tribunal is constituted, what they would normally do is to consult the parties, ask for their views. And I suppose things like where the transaction was to be carried out, where the contract was signed, place of incorporation of the parties, or governing law in related contracts, if there was a suite of transaction documents, would all be potential factors which a tribunal would take into account.
Thank you for everyone's question and participation. And also thank you very much, Ms. Lau and Ms. Cheung, for those valuable insights. Your presentation has clearly shown the HKIAC rules provide both structure and flexibility, something that joint venture parties really need in today's complex investment landscape. And now, Ms. Noppramart will continue her next session about JV dispute in arbitration cases, lessons from real proceedings, where we will analyze the case study and key takeaway for Thai and international perspective. Please give another round of applause for every speaker.
Okay. Okay, thank you. Thank you, Joanne and Michelle. So now we come to the JV breakdowns to the licensing wars. This case is a Thai case related to international arbitration. I want to share with you about this case because I think it's interesting when we put the arbitration clause, and we think that this could solve any issue. But in the real life, as the litigator and even myself as the arbitrator, I can say to you that no, it's not always like that. It always can be like parallel wars. First war in arbitration, second war in the local court. So that is something that you may need to bear in mind. Coffee war in Thailand. If you know Nestle is the producer of instant coffee. Okay, and this Swiss company, right? They own the the trademark Nestle coffee around the world. And also they come to Thailand 35 years ago with the plan that they want to expand the market. It's very normal that for the foreign investor who want to expand the market in the local market, they need the Thai or the local partner, right? Same thing. This Nestle Swiss company also find a Thai business family. I say family. They are well-known Thai business family, right? And this, I call them Maha family. Actually, I don't want to say their full surname. Okay, this Maha family, they enter into the JV agreement with a Swiss company, the Nestle company, like to set up a JV company called Quality Coffee Product. Right? This is a JV company. It's a Thai company, right? So this company have been set up 1990, right? Long time ago. They must be really good friends, right? For a long time. So what is the purpose of the JV company? The JV company is to carry on the IP, the trademark and the formula of the coffee and everything that this JV company have to enter into another agreement called licensing agreement concerning the technology, the IP issue and the formula of the coffee. And IP ownership is still with the Nestle, right? So they have been successful in Thai market. Why? Because they are the #1 instant coffee in Thailand. They are dominant, this Nescafe dominant in Thai market. And what happened? Along the way, yes, from time to time, party want to continue, right? But as you know that for Nestle, they think that the market quite certain, 35 years already, but the other Thai partners, they think that they need more shares from this JV agreement, right? I can tell you that I'm not the lawyer, I'm not involved in this case. I share with you about this case and all the information and fact I collect from the newspaper, online information. And I share this case with my LLM student as well. So I'm not breach of any confidential agreement. Okay. And so what happened? I heard about this case at the beginning of 2025 when the contract JV agreement already terminated. But I think that before Nestle terminated the JV agreement, probably they already have the long discussion with Maha family, the Thai partner, right? But maybe they cannot end the JV agreement, not in an amicable way, right? So then Nestle filed the case with ICC arbitration, right? And the ICC tribunal confirmed that the termination of the JV was lawful. Seem everything quite easy, right? But the issue in this case is very interesting because there are like 4 litigation cases in Thai court. You see, another 4 litigation cases in Thai court. None of them about arbitration. You may guess from this slide that they probably fight for like set aside the award or whatsoever or enforcement of the award. No. Okay, what happened for the case? And another question that I still thinking. And if some of you involved in that case, you may tell me after this presentation what happened with the licensing agreement, because the tribunal only confirmed for the lawful termination of the JV, but I don't know whether or not this award already include the termination of the licensing agreement, right? So this also, when you handle the arbitration case in Thailand, when I asked Michelle and Joanne about the interim relief or interim measure, you think that Thai lawyer really obsessed with the interim measure? Yes, because it's the way to protect our client right and property, right, during the case ongoing. So in Thailand, if you want to go for the interim measure, unfortunately, if you use HKIAC or other institute that they provide the emergency arbitrator, yes, you can get that interim measure from the EA or emergency arbitrator. However, I'm not really sure whether or not Thai court will enforce that order for you, because Thai court might inform you that under the Thai Arbitration Act we can only enforce the final award. Interim measure is interim, go back home. Okay, so that is something you have to bear in mind. Okay, first case, but actually it's not first. Before this first court case, Maha family already sued the case against Nestle in Thai court before the termination of JV agreement. If you have your partner, JV partner, sue you before the end of the contract, it's not a good sign. You need to prepare a tooth of lawyer, because the storm will come, okay? The storm will come. Like, same thing like this. They already sued Nestle, the case finished. Then Nestle sued them in ICC arbitration. The tribunal confirmed, good, lawful termination for JV. Why? Maha family sued this first court case under tort law. What they claim? Like Joanne said, the governance of the JV, the governance of the company, Nestle appoint director act improperly. The director act improperly, damage Thai shareholders. This is based on tort claim. Why? Actually, this still should be still under the JV agreement. But why they don't come back to the enforcement of the award or file another ICC arbitration? Can they? This is Thai way. I think it's Thai way. Thai way to use the court case. If they want to avoid the arbitration, they use tort claim, right? What Maha family try to do right now. They said they asked the Minburi Civil Court to issue the interim injunction. But for this case, Minburi Court dismissed the application. Right? Dismissed the application. They file again. They file again in another case. You see, first case not finished. They start another court case. Maha family start the second court case based on the claim that Nestle failed to cooperate with licensee with the JV company. Again, it's under the scope of JV. Even though JV terminated, what happened? Why you come to this creative legal ground? But for this one, the Maha family successfully obtained the court injunction order. And the court said that stop all selling Nescafe products in Thailand. Oh, big order. You know what I'm worried? Where can I buy Nescafe at that time? I think many media screen this news and people think, oh, I have to stock Nescafe, right? I asked my student that if you were the Nescafe Counsel, what you going to do? You ran back to the ICC arbitration? What you want to do to fight back with the Maha family? In this case, in this second court case, Nescafe also object the court interim measure, interim injunction. If you read from the court order several things. Not only stop selling all the Nescafe in Thailand, and also return machinery and equipment to QCP factory. What does this mean? It means that the factory already uninstalled the machinery and everything and closed down the factory already because it's terminated the JV agreement. But as I told you, it's questionable in this case. What happened with the licensing agreement? It should tie together, right? It should tie together. Once you terminate JV agreement, it means that licensing agreement should end. But what happened in this case is messy. A lot of messy. Right. Okay. And then the Nestle Counsel fight back and said that no. This case is about the trademark case. It's not under the jurisdiction of Minburi court case. You go to the wrong court. And then Nestle lawyer ran to the IP court in Bangkok. We call intellectual property and international court. Right. But file another case. Nestle file another case to support his objection against the jurisdiction of Minburi court. Again, they fight over the tort claim. They say that QCP, JV, and also Maha family cannot use Nestle because the trademark owner in this case is Nestle. Right? So, and it's really for IP court. They are specialized trademark and they say, oh yes, you show me the trademark owner And then I can order the emergency injunction. Nestle requests IP court for emergency injunction to protect Nestle brand. By ordering that Nestle can be on Thai market. It's just like automatically revoke Minburi court order, right? Okay? It seems like Nestle Counsel just happened to be clever after 2 cases already. Okay. So, for this case, for this IP court, Nestle claim that they have been lost for approximately 70 million per day, right? And in order to obtain the injunction, they have to put the money security in case that Maha family can prove that they have the right to use the trademark, Nestle trademark. I don't know how much money that they Nestle have to put the security against this injunction order. But the media claim that Maha family, Nestle lawyer complained that in Minburi court case, Maha family only put the security like 50,000 Thai baht, very small money. But it put a lot of loss, like 70 million per day against Nestle. And before Thai New Year, Songkran festival, I think that Nestle got the good court order, right, for this injunction. And also Minburi court, they have the issue of the fighting which court have the jurisdiction over Minburi or IP court. And this issue have to be decided by the chief of the Court of Appeal judge. Finally, the chief judge of the Court of Appeal decided that this case is relating to the trademark. It should go under the IP court. Then Minburi court no longer have the jurisdiction to decide the case. Then, right now, the case in IP court not finished yet. I think maybe next year. The case just started this year and it maybe go on until 26 next year. That's for the first instance court. Again, Nestle sued another case for the case number 4 to dissolve the JV company, right? Because they said, okay, the tribunal already said that my termination is lawful, then I can dissolve the company. This case is still ongoing, right? It's still ongoing, not closed down the JV company yet. As you can see, this I can conclude to you until now, they have 5 court cases together, even though they have the JV agreement. I think that for the JV joint venture agreement, not only with Thai party, but I think other countries also have facing the same problem, right? So better that party, either foreign or the local partner, they have to consider if you put the arbitration clause, whether or not you should go on fight based on arbitration award, or you again, or if you want to run away from the arbitration clause, you always claim that it is the tort claim, it's the wrongful act claim. So you will have to prepare for this kind of tactic. that we are as the litigation lawyer always use. Okay. Comparative JV case, same thing. This happened, I told you, like Carlsberg is beer, right? Beer. Carlsberg want to set up the beer brewers factory in India. They find the JV company, right? They put the arbitration cost, right? Same thing. But in this case, again, who hold the license control? Usually the foreign party bring in the IP, trademark, know-how. They will draft the licensing agreement in detail and to protect their intellectual property right, strictly. Right. So I think that you cannot focus on only JV agreement, but you will have to consider the licensing agreement. Let's go together. Or sometimes I found that I have some of client who's the like innovative people, the engineer who really bright, and they have really good idea to do the business, but they don't have money. Then they have the investor. They have to go to the investor to expand their investment. These startups will have to consider a lot how they hold and control the licensing and the know-how and trademark or patent. I think this is really important. Another second case that you may want to find out more is like Danone. I think all of you know Danone. Danone is like milk dairy product, milk yogurt. French company invested in China. Again, when you invested in the big country and your local partner know best about the law, their own law, they know the government officials, they might think that, oh, I have obtained some know-how and then, oh, I can do it, better milk, better yogurt. Then they compete with you. They ignore and breach the competition, anti-competition clause, right? Okay. This is the example that I want to share. And again, try to not only focus on the arbitration clause, but when you are in the game, I always say like this, when you are in the game of litigation wars, you have to see the parallel. Because it's not always in arbitration, it can be anti-suit injunction, it can be other litigation cases that your lawyers will have to advise you case by case. Like, for this, Nestle is only one case that I think is good to show how the arbitration clause, how Thai lawyer in this case, they ignore the arbitration agreement. They know what is the arbitration clause, but they try to ignore because they want to use Thai court. Okay. I like to finish here, and we host lunch and we can have a chat over the lunch together. Anyone want to ask me any question, please? Okay. And if no more question, I can close this presentation and seminar. And I again thank you for HKIAC. And I have to say that we have enforced HKIAC in Thai court, in IP court. I think several awards, never been turned down. Okay. Yeah, and I can tell you that we probably have one or two cases that might go to HKIAC. Yeah, cannot say anything about the party, but I think that HKIAC is still a good reputation in Thailand. Yeah, please come more often. Okay, thank you very much. Thank you, attending. Thank you.